Mr. Soo consulted Dr. Kok about a lump in his forearm, and Dr. Kok said and advised to him to undergo a surgery to remove his lump. So on 14 September 2004, he performed a surgery at Sunway Medical Center and removing the lump. So after the operation, Mr. Soo feel a pain on his forearm, the place where a surgery take place. So he went to the hospital, to the Pantai's hospital, and the doctor said that he suffered a nerve damage. Because of that, he need to undergo a few more surgery. So Mr. Soo has suffered injuries, medical expenses, and others. So Mr. Soo take his action to the High Court, whereas he sued the doctor and also the hospital. So the High Court judge found that the doctor and the hospital is liable towards Mr. Soo. So the High Court allowed the claim of the plaintiff against the doctor and also the hospital. So the doctor and the hospital make an appeal. However, Court of Appeal found that both of them still liable towards Mr. Soo. But the Court of Appeal rejected the claims of Mr. Soo of his medical expenses on his surgery.
Because of that, the plaintiff brought an action against the doctor and also the hospital in High Court. First of all, the High Court found that the doctor is liable in negligence as a capacity as a medical practitioner. And the second one is the hospital is liable in negligence because they fail to provide a good healthcare service, including the competence, skill and expertise of the doctor. The next one is the trial judge also found that the hospital owned a non-delegable duty of care, which is vicarious liability to sue. Next, High Court approved the claims of the defendant, the doctor, and awarded 50,000 for general damages for pain and suffering. And after that, the court also approved the amount of 5,100 for the special damages for the defendant for psychiatric and travelling expenses. However, the trial judges had rejected Soo's claimant of the amount 19,632 and 84 cents for the medical expenses, which is paid by Soo's insurance. The hospital appealed against the vicarious liability for the negligence by the doctor, and Soo also appealed on the claimants of the insurance, but Soo's appeal was rejected by the court. Based on the Woodland case, Court of Appeal concluded that hospital actually has a vicarious liability towards Soo and rejected the relevance of Soo's own choice in engaging doctor service at the hospital. Hence, the Court of Appeal dismissed the hospital appeal. After that, the Court of Appeal allowed Soo's appeal on quantum based on Section 28A, Subsection 1, Subsection A of Civil Law Act 1956. And after that, Court of Appeal also approved two appeal, which is liability of the hospital and also the doctor's appeal against the decision of quantum. The hospital argued that the doctor is not the employees of the hospital. Instead, the doctor is actually an independent contractor of the hospital, which is contrary to the private healthcare facilities and services for the private hospitals and other private healthcare facilities Regulation 2006, which is they cannot impose a non-delegable or vicarious liability towards the private hospital. And last but not least, Soo argued that the hospital should be responsible for the risk regarding its commercial enterprise. Patients should be able to look the hospital's deepest pocket to recover damages. The court held allowing hospitals appeals and also dismiss the appeal on quantum. So we will hear the judgment of the hospital appeal from my next friends. Thank you.
Okay, for the second judgment, the council argues that all private hospitals are always or never under a non-delegable duty to patients. So the court reject this argument. So the council, they use the test of woodland cases. They use the landmark cases used is the woodland cases, which features 5 features. So the first features, it had been satisfied in the cases, but the second features cannot be satisfied. It had been proven that Dr. Kok, in fact, the one who managed the plaintiff herself, she is the one who issue the appointment date, and she is the one who undertook the operation. So it is solely on Dr. Kok, and because of the second feature cannot be proven, hence the third, fourth and fifth features does not arise. The third features, which is how hospital chooses to perform the duty, or how the hospital delegation of an integral part of the duty, and the negligence in the performance. So all these 3 features does not arise. So regarding the policy argument, that the hospital had undertaken a commercial enterprise for profit. So that should be in the consideration of Soo when she decided to have her treatment with Dr. Kok. So Dr. Kok. So this argument is contrary to the non-delegable duties, because the non-delegable duties were not imposed based on financial means or profit. So to conclude, the hospital was not liable for breach of non-delegable duty to the plaintiff. Moving on, based to the recent decision, it seems that the boundaries of vicarious liability had been expanded, not to only among the employer and the employees. It also covered even the relationship between that is sufficiently akin to the employment, but not to include to those who were clearly independent contractor. The court needs to determine whether there is obvious relationship between Dr. Kok and the hospital. Yeah, so it seems that Dr. Kok only managed the plaintiff by herself. So there are not a lot of interaction between Dr. Kok and the hospital. So Dr. Kok had to. It is in fact the negligence is only on Dr. Kok. That's all.
Okay, I explain more from our friend Zulhaili. So the court said that the plaintiff has right of action against a defendant for the full amount of loss, and that was indemnified by an insurer. So whether or not the insurer choose to exercise its right or subrogation. So the court applied the principle that's get from the cases cited to the present case, which is the case about the medical expenses for the treatment of the injuries suffered by Soo were a natural and direct consequence of the doctor's negligent act, which is the doctor was liable. Then Soo was entitled under his insurance policy to have the expenses paid for by his insurer by make a contractual agreement with his insurer, then paid the premium to provide contingency. Soo's contract with insurer was an extraneous collateral and matters. So it did not affect Soo's claim against the doctor for the damages suffered by Soo as a direct consequence of the tort. Hence, Soo maintain his right and of action against the doctor for the full amount of damage suffered, including those expenses. So, and so entitled to his claim for medical expenses of 19,632 ringgit and 84 cent under both the common law and section 28A subsection 1 subsection A of the Civil Law Act 1956 that we can find in paragraph 106 until 107, and then 110, and then 116, and then 129, and then 136, and then 139, and the last one, last but not least, 154 until 155. That's all from the judgment. Thank you.